Thank you for the shushing. Good afternoon, this House Judiciary Committee. It's Wednesday, the 13th of March. It's a little after 4 o'clock, and what better time to start voting? So let's go ahead and do that. We're going to start with an administration bill. So naturally, we're really suspicious. Oh, hi, Mr. Lukey. How are you? House Bill 123. House Bill 123 is the first bill that we have. There do not appear to be amendments. And let's this is Claire, who is sitting right there. This was a moon hold from our last installment, but I believe, have your questions been answered, Delegate Moon? I believe his questions have been answered for the purposes of this bill. I think he's making reference to another bill that now is too expensive that doesn't actually exist yet. Having said that, there was, well, let's see, is there a motion on the bill? Motion for a favorable. Is there a second? All right, that sounds good. Is there further discussion on House Bill 123? I see. Seeing none, the Vice Chair? Yes. Munoz, it's her daughter is sick? Yeah. All right. Crutchfield? Yes. Yes. Carden? Yes. Sample Hughes is absent. Embry? Yes. Pasteur? Yes. Tolles? You have to tell me yes or no. I'm sorry. This is 123.
It's the governor's bill.
I can't pass you. You gotta. We don't do that anymore. It's 1, 2, 3. Yes, that's fine. We're marking you as a that's fine. Schmidt is a no. Simmons? Yes. Boucher? No. Phillips? Yes. Roberson? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
Motion passes. House Bill 214. This has to do with, there's a motion for a favorable, there's a second?
Second.
And a second. House Bill 214, it deals with the adoption of an adult. The Family Law Committee, however, did. Madam Subcommittee Chair, would you like to discuss this at all, or would you give a little insight into the bill?
I can do that.
That's great.
First of all,
parental consent is not required for adoption of adults under this bill, and also show cause orders are not required. Usually those were used with minors during their adoption process to just give parents an opportunity to really object or to have notice. So those are the two main things that are no longer required for an adult adoption, to just streamline things and just really make it clear that adults actually should be able to go ahead and choose the people that they want to be around.
All right, there's motion for a motion for favorable and second. Is there any discussion with regard to the bill? Seeing none. What is this? 214. I have to write this down here. Otherwise, nothing works. All right. The Vice Chair.
yes.
Yes. Crutchfield?
Yes.
Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Okay. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
All right.
Yes.
From the hallway, Delegate Tolles, yes. That was 214, by the way. All right, Delegate Schmidt appears to have taken responsibility for that. All right, House Bill now is 321. The first one was 123. Now it's 321. Well, you know, we totally planned these things. There is an amendment. This went to subcommittee with Delegate Moon. Delegate Moon, do you feel like you can talk about what the bill as amended would do if we pass the amendment?
Sure, the bill as it came in sought to add 10 years to a range of arson and burning crimes if you caused a injury to a firefighter. The subcommittee discussed this and felt that it was more appropriate to put that added 10 years on the crime of malicious burning or a insurance fraud related burning, because those came with a much lower 5-year penalty that did not contemplate a likely death or injury to a human being, whereas the arson crimes that were already included carried 30 for even a mere injury because they're building in a possibility of injuring a human. So that's what we did. And we also changed injury to serious physical injury or death. And with that, I believe it was unanimous on the amendments and the vote.
Move the amendment.
Motion for the amendment. Is there a second? All right, we're on the amendment. Discussion on the amendment. Okay, seeing no discussion on the amendment. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 15, 16, 17, 18, 19. Anybody opposed? The amendment's adopted. We're on the bill as amended. There's a motion for the bill. Is there a second? Motion for favorable as amended. Any further discussion on the bill as amended? Seeing none, the vice chair.
Aye.
Aye. Crutchfield. Yes. Carden. Yes. Embry. Yes. Pasteur. Yes. Tolles. Schmidt. You have one job to do. Schmidt. Yes.
Yes.
Okay. Yes, and an add-on. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. This is 321. Simpson, yes. Grammer. Yes. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes, and an add. Williams.
Yes.
Yes. I only heard 2 adds. Schmidt and Kaufman. Simmons, Conaway. Carden. Erican. That's all I'm doing. All right. 321 moves. Do you wish to vote on House Bill 321? How would you vote on House Bill 321? Great. Okay.
I know, we're so simple. We noticed.
It's not Delegate Schmidt's fault. All right, so let's go with. All right. It's not Schmidt's fault. All right, so we've had this bill before. It's first time on the voting list, though. How this year at least, House Bill 346. There's a motion for a favorable and a second. Everybody, for those who, this is Delegate Moon's something for everybody bill. It has the removal of a mandatory minimum. It also has making the possession of a stolen firearm a felony, among other firearms crimes. Do people want a description of the bill again in particular? Yeah, people do. Delegate Moon, do you want to take this from here?
Let me put my orange down. Thank you, Mr. Chair.
Thank you.
House Bill 346 does several things. For one, it incorporates Delegate Grammer's prior clarification to our cannabis reform law that if you, not for commercial purposes, and are not using a volatile compound, that you can produce brownies and other such products at home without facing the criminal penalties. Yeah, that's the tiniest piece of the bill. The other parts of the bill, for one, it removes mandatory minimums on high volume cannabis possession. Currently, that could be 10 or 20, depending on how much it was. So we have a mandatory 20 up to 40 for cannabis offenses still on the books, which seemed inappropriate. So we took off the mandatories and dropped that number down to a maximum of 10 for that offense. In addition to the repeal of that mandatory minimum, the bill provides a hearing for people who are already incarcerated under that penalty. And it goes back and makes a correction to another equity issue where several years ago, in that same section of law relating to high volume dealers, it had a section, it has parts of crack and cocaine that are in there. And some time ago, it required 8 to 10 times more cocaine than crack to land you that 20-year mandatory minimum. So we fixed that years ago and made the crack and cocaine amounts the same. But if you were previously convicted under that crack mandatory, you're sort of stuck, and we didn't give you a way out. The bill provides those folks a one-time hearing to try and modify their sentence. And on the cannabis, again, it would allow people to go in and request, I think, a modification every few years or so. So that's the criminal justice, hopefully the warm and fuzzy part of the bill that you like. There's also on the guns end of the bill, it upgrades a few firearms crimes from misdemeanors to felonies. And these are all crimes where you have put on the market or procured firearms by avoiding our background check and regulation system, and or making these guns anonymized in some way so they can't be traced. So the offenses that would upgrade from misdemeanor to felony are stolen handguns, handguns with a scratched out or obliterated serial number, there's ghost guns, stolen guns, obliterated serial number. And then the Senate last year, at the last second, threw on a Joe Carter amendment, which was to upgrade firearms trafficking from a misdemeanor to a felony. So those 4 felonies are now included in this bill. And I believe that's it.
Questions? Delegate Conaway.
Thank you, Mr. Chairman. So what is the maximum amount of marijuana that we're talking about here?
This is
The weight?
50 pounds in a 90-day period. And that could be the amount the operation handled if
Okay.
you're having multiple people.
And in reference to the manufacturing of, I guess, personal supply or whatever, does this include that resin type of marijuana, the marijuana resin?
It doesn't specify what the method is as long as it's not commercial and does not use a dangerous production method.
Okay, all right, thank you.
Other questions? Delegate Tomlinson.
Thank you, Mr. Chair. Could Delegate Moon, could you, and I know you and I have talked a lot about this bill and I appreciate it. Could you, I've got a hard copy and it might not be the most recent version, I don't know, but I know on page 4, there's references to opioids and fentanyl and meth, what relate, how does this bill relate to those?
It doesn't change anything with
Not changing
respect to
anything.
anything. If it's a cannabis, high volume cannabis, that's a change. And it doesn't actually change anything with respect to crack or cocaine, except for to give people currently incarcerated under the old mandatories a hearing. But otherwise, all the other drugs penalties are untouched.
Okay, I just wanted to make sure. Thank you.
Yep.
So just want to make sure and you and I've had a conversation. So if you could go on the record about the enhancement of penalties using guns and when that would apply.
So you said not using, the delegate had asked whether this was a penalty enhancement, and we did not change so all of those firearms offenses, ghost gun, stolen gun, obliterated serial, and trafficking are existing crimes. They're just misdemeanors. And so the bill bumps them into a felony category. Part of the reason for that, to be perfectly frank, is if you look at the fiscal note on this bill and last year's version of the bill, you'll see very, very few charges or convictions for this range of offenses. It's just milling these cases, getting people on simple possession of the gun, and then we go on our way. And so the idea was that you bump these into you make them circuit court cases, they're felonies, they're going to get treated a little bit more seriously. And so that was, just to be clear on the motivation, I think that was part of what was driving it. Now, as to whether you're going to get a enhanced penalty, if the felony versus a misdemeanor, is it less likely to plea? I don't know, right? There's structural questions like that certainly could come into play, but not on the text of it. Now, on the other hand, if you were to commit an additional offense later, you're now a felon. You're a felon committing a subsequent offense. And I would say there's a possibility that you are going to be put in a worse position than had we not upgraded those charges to a felony. So if you do something again, I do suspect you could be looking at some consequences.
So this would be first time you're carrying a ghost gun, we're moving that from a misdemeanor to a felony. Okay.
So I want to go from what Delegate Scott just said. Phillips, that Scott is still his first name. Phillips just said. So the first time, are there any circumstances under which that would not be the case? And I'm thinking just of some silly little person who, however he acquired, but hasn't done anything with it. You know where I'm going?
I mean, I think a first-time offender who has a felony is looking at a felony possession charge. I mean, we've got practitioners in the room. I would still be surprised if you're doing hard time of any kind on a first-time offense. Just possession, you didn't actually do anything else. I mean, way back when, and this is again, like, you'll have to decide what you think the actual thing that should be done with some of these cases is. But, when I was looking at old numbers back in the old bump stock debate, it was very clear that people aren't doing time for these possession charges. You'd see hundreds of wear carry possession charges in Western Maryland and very few convictions and what have you on those. And so is that going to change with this on a first offense? Again, we have practitioners here who may beg to differ, but I don't think it's likely that you're going to see someone doing real time for that.
Delegate Moon, if you'd yield for a moment.
Yes.
What I believe what you would also see is somebody, if they were charged with the felony, with what would be a felony charge of being in possession of a ghost gun, they'd also be charged with being illegally wearing and carrying a regulated firearm, which is going to remain a misdemeanor and doesn't change under this bill. So that is the more likely charge if they're if they're going through the process for the first time. Having said that, I think that the idea here was to look at, I mean, we've heard a lot of legislation about stolen firearms. We've heard a lot of legislation about ghost guns. And those, particularly being in the flow of commerce, they're a level above being in simple possession of an illegal, of a firearm illegally. So that's why there's the distinction in the bill. All right, Delegate Conaway.
Thank you, Mr. Chairman. Can you speak a little bit more about being in possession of a firearm illegally versus being in possession of a firearm that's a ghost gun?
If you were in possession of a handgun and that you could say, all right, you're in possession, but you don't have the proper license,
Right.
then then the offense that you're violating is the wear carry. It's not, that's what that is. You can also be charged with possession of a ghost gun if it were a ghost gun, or possession of a stolen gun. It's still a regulated firearm that you're carrying illegally.
So
So you would get charged with all of them, but what the prosecutor decides to go forward with, it would just depend.
Thank you, Mr.
Yeah.
Chairman.
All right. There was a motion for the bill as a favorable, and it was seconded. I don't see anybody else raising their hands, so the vice chair.
Yes.
Yes. Crutchfield? Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Briefly.
Struggle with some of the drug stuff. So I just, I want to just be on record saying there are pieces I really like. I appreciate you working on this. I know we worked on it a long time last session. Thank you. Thank you for bringing the bill, but will be a no for some pieces that I just don't agree with. So thank you.
Simmons? Yes. Boucher? Phillips? Yes.
I appreciate the bill and I understand where we're going with the gun enhancements. I am a little uncomfortable about automatically making some of these things felonies because they do carry a significant amount of weight. At the same time, I've got a bill that we're trying to push forward to hold manufacturers and sellers liable for selling ghost guns. I hope we get not only the possessor, but those individuals that are responsible for putting those in people's hands. Thank you.
Robertson? Yes. Tomlinson?
No, but can I explain my,
Briefly, yes.
yeah, exactly what Stu said, me too.
Okay.
I don't know if we're allowed to do that on this,
You
but
just me too. Okay.
me too.
Eric Ann? No. Taylor? Yes. Simpson? Yes. Grammer? No. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes, for the delegate from Tacoma Park.
All right. House Bill 346. Thank you very much. I'm not sure what that means. 382. Wait a minute. Who sponsored this? Oh. Want to explain your vote on this one? There. A dubiously sponsored, dubious sponsor on the legislation. However, it is Delegate Schmidt's first bill, at least in here. All right, there's a motion for a favorable and a second. All right. Well, I don't know.
I don't know, Mr. Chair.
Discussion, I guess, on the bill.
Yeah, lots.
Lots of discussion. Delegate Schmidt, why don't you tell us what the bill does?
Previous.
No, tell us what the bill does.
Thank you, Chair. Thank you, Chair. I appreciate you asking.
Yes.
We talked about this. This is a protection for professional land surveyors. It does afford them some rights to be on property to do their job once they identify themselves. So this was something that was brought to our attention that became a problem. They do announce that they're there, and this just allows them to do that. If they're not welcome, they will leave the property. But it just ties up a loophole on trespassing.
Does anybody have any in-depth, deep questions they'd like to ask Delegate Schmidt on the bill? No. All right, the vice chair.
Yes, and I'd like to explain my vote.
I'm just joking. Go ahead.
Crutchfield?
Yes.
Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Simmons? Yes.
So, I know during the.
Oh, he's serious, actually.
Yeah, no, I am. I am. So I just wanted to, just thank the bill sponsor. I know in testimony, there was some concerns about minority employees while on these surveys and putting their lives in jeopardy while out on property. So, any measures we can take for fairness in the workplace, I really appreciate it. So thank you, sir.
All right. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right. Congratulations. Oh, Schmidt? Schmidt? Yes, excused. No, yes. All right. There we go. House Bill 485. There's a motion for a favorable and a second. All right, there are no amendments. This is a straight favorable. Is there discussion on the bill? This bill deals with eliminating the crime for the prohibition that prohibited the transfer of HIV. We've had this bill before. Any further discussion? Seeing none, the vice chair.
Yes.
Yes. Crutchfield. Yes. Carden. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. No. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. No. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. No. Moon. Yes. Valentine. No. Conaway. Yes. Kaufman. Yes. Williams. Yes. All right. That one's done. House Bill 528. Oh, Delegate Buckle. All right, is there a motion on this bill? There's a motion for a favorable. Is there a second? All right. 528. I'm sorry? You really want to use your hold? Okay. One time, we'll see this tomorrow. Okay. Welcome to the fun part of our session, everybody. Let's go to House Bill 531. There's a motion for a favorable on House Bill 531 and a second, questionable sponsor, of course, but still. Oh, this is that bill, 531. It's about the fees. The parole supervision fees that they charge people after they've been in jail 15 years. Okay, there are no amendments. So we did that part. We moved in second. Any discussion? All right, the vice chair.
Yes.
Yes. Crutchfield? Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes, and explain for the guy who only got a call during COVID to make sure he was alive. It is definitely for us.
Yes. All right. Moving on now to House Bill 542. Luggage. There's a motion for a favorable and a second.
There are.
But there are amendments, so we're gonna roll that back and we're gonna try again. All right, Madam Subcommittee Chair, if you'd like to talk about the amendments, please. Well, let's actually do that. Is there a motion on the amendments? Yeah, there's a motion on the amendments. Is there a second on the amendments? All right, fine. Do we have? One moment, please. Amendments 483728.
We're gonna put it up there. Oh, okay.
Do you need to come up? You want to come up and? Yeah, come on up. All right. I think they're clarifying more than anything. All right, so Lauren's here. She can tell us what the amendments do.
Okay, that's right. They are largely clarifying. They're clarifying that new luggage for a child in foster care does not include trash bags. They expand the circumstances under which the department must provide new luggage to a child in foster care. So that would be entering foster care, moving from one foster care placement to another, or exiting foster care. They require the department to take into account certain factors when providing the new luggage, and those factors are the child's age, mobility, personal items to be transported, and preferences. And they prohibit the department from using disposable bags or trash bags to transport any items of a child in foster care.
Should have a second on the amendments. Any further discussion on the amendments? All right, all in favor of the amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22. All right, anybody opposed? Don't think so. All right. Amendments are adopted. We're on the bill as amended. There's a motion for a favorable. Is there a second? Yes, there is. All right, on the bill, just as an aside, anybody in the state's care who should have to leave from one place and go to another place and be forced to put all of their belongings in a black trash bag is one of the absolutely most horrible things that we can do to a child. So I wonder how this chair is going to vote on this bill. Anyway, I think providing them with luggage, I would say, I want to recognize the secretary for indicating that they're already taking steps to make sure that we don't allow that to happen anymore, and to make sure that they are given luggage going forward. All I believe that we're doing with this legislation is basically putting an underline under it and putting an exclamation under it. Did I get that right, Madam Subcommittee Chair?
I believe you did. As a matter of fact, the Secretary Lopez actually has put together a policy, and that became effective last week, March 5th, that this should no longer happen.
So very much appreciate the administration's work on this, but we're gonna say our piece too. If you feel like voting against it, say your thing. but-
No, just Mr. Chair, I remember the subcommittee discussion, and we too appreciate Secretary Lopez's hard work. But secretaries come and go, governors come and go. So it's the sense of the subcommittee, based on my recollection of the discussion, that people would feel more comfortable codifying this, which is why it's here.
Further discussion, Delegate Valentine.
Just a comment, Mr. Chair. Thank you. I just wanted to piggyback on Delegate Kaufman. I did on the subcommittee as well. secretaries come and go, policies come and go. This will eliminate ensure that that will not happen. Thank you.
All right. I think we should vote on this. The vice chair.
I strongly vote in favor of this bill.
Yes, exclamation point. Crutchfield. Yes. Carden. Yes. Embry. Yes. Pasteur. Yes, with an exclamation point on it. Yeah, I suspect I'm gonna have to do something here in a second. Tolls. And an ad. Okay, so before I go further, the vice chair, do you want to add on?
No.
Crutchfield?
Yes.
Yes, adding Crutchfield, adding Carden, Embry, you want to add on? Okay, Pasteur, yes, all right. Schmidt, yes, and an add-on. Simmons, yes, and an add-on. Boucher, yes, and what? And empathy, is that an add-on? Is that what we're calling it? No add-on, all right. Phillips, yes, and an add-on. Roberson, yes, and an add-on. Tomlinson, yes, and an add-on. Erican, yes, and an Erican. Taylor, yes, and an Erican. Simpson, capital yes, and an add-on. Grammar, yes. Moon, yes. Valentine, yes, and an add. Conaway, yes, and a Valentine. It's going to become very confusing. Kaufman,
Yes.
yes, and a Conaway. Williams,
He's already on the bill.
oh, well, we'll figure that out. Williams,
I'm just yes.
just yes. Chair votes aye. All right, and I made the notes on the voting sheet, and you can, whenever you want, that's fine. Okay, we have an amendment on House Bill 565. House Bill 565 is Delegate Simmons' bill. Simmons, I think there's some concern. All right, so my understanding is that this amendment, and this is one of Claire's bills, puts it in the same posture as it left the Senate. Is that correct, Delegate Simmons? So it basically becomes a reporting requirement from the state police, am I right in
That is
understanding that?
correct as well.
And so everything else in the bill goes away,
Yes,
thus addressing a fiscal note and everything else.
correct.
Okay, is there a motion on the amendment? There's a motion on the amendment. Is there a second? And a second. Any discussion on the amendment? Seeing none, all in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? Amendment's adopted. We're on the bill as amended. Motion for a favorable. Is there a second? And a second. All right. Any further discussion on the bill as amended? All right. The vice chair?
Yes.
Yes. Crutchfield? Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? This is your bill, delegate. You understand? Boucher? Yes. Phillips? Yes. Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammar? Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman?
Yes.
I think that is enough. Favorable is adopted. We're going now to another administration bill. My goodness. 575. There are no amendments to the bill. There's a motion for a favorable. Is there a second? Yeah. Never mind. Roll it back. We're not going to listen to that silly motion. There are amendments we have to think about. Claire, can you come and tell us what the amendments about the amendments, please? Is this the one where? All right, this makes alterations to the victim compensation statute Claire, could you tell us what the amendments do and what the bill does as amended? Moment, please.
So the amendments add dentist to the definition of qualified third party and makes the authority of the board to delegate to employees of the board the ability to hear and determine claims optional and makes a clarifying change.
This is 575.
575.
Yes.
Counsel, when you say a qualified third party, in the context of the bill, what does that mean?
Somebody who can receive a reimbursement directly from the board.
So if there's a victim who needs work from a dentist, that would be, I mean, you just said that, but just making sure everybody understands, it just means that the dentistry bills would also be able to be paid under this amendment.
Yes.
Okay.
Move favorable.
There's a favorable on the amendment and a second. All right, discussion on the amendment, Delegate Moon.
Sorry, I have a just discussion on the bill. You can skip me for now.
You want to skip the,
Yep.
okay, well, let's do the amendment. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Anybody opposed to the amendment? Not seeing none. All right. So now we're on the bill. Delegate, on the bill as amendment, is there a motion on the bill as amended? Favorable, is there a second? All right, discussion, Delegate Moon.
Thank you, Mr. Chair. I'm just reading the fiscal note on the first page of it under fiscal summary where it says state effect. It says no effect in fiscal 25. And then it says general fund expenditures increase significantly, and significantly is italicized, beginning in fiscal 26. But in skimming the rest of the note, it's hard to tell what significantly means in the context of this note. Do we have any clarity on that?
I do not. And if you'd like to hold on to it for a second so that we can get greater clarity about that, I think I'd like to do that just to make sure. Because we are, one of the things that I'm getting loud and clear from across the hall over there is that we have to be careful about fiscal notes. So to that end, I'll hold on to this and we'll do this. And then if people still have questions, I don't mind holding on to it just to make sure we get any more data, but Claire, go ahead.
Well, if you look at page 7 of the fiscal note, it says general fund expenditures increased significantly beginning in fiscal 26 to provide additional funding to support the expanded operations of the board and eligibility for compensation effective July 1st, 2025.
Also in the bill that it expressly says that in fiscal 26, so not this year, but next year, it says that the governor may include in the budget bill an appropriation adequate. So we're kind of passing the policy changes now by passing this bill, but they'd have to figure out where the money was next year. It's a may, not a shall. It does increase the amount of funds in several different places. If you feel in any way unready with this, then I'm fine to hold it till tomorrow.
Well, I guess it's unclear whether the significantly terms refer to that 1 million or whatever. I'm again now looking at page 8 of the fiscal note. And if you look at the bottom of the third paragraph, it says, although a precise estimate cannot be reliably made beforehand, these factors are expected to significantly increase annual CICB expenditures.
So what I see in the bill is I see that it increases the amount of funeral expenses that are covered from $7,500 to $10,000. I see an increase in the amount that's available for psychiatric, psychological, or mental health counseling from $10,000 to $45,000 for a claim. An increase in the amount available for the repair, replacement, or cleaning of property damaged, soiled, or littered as a result of crime from $250 to $2,000. And it also raises the amount of an emergency award from $5,000 to $10,000, which honestly for the emergency awards are there for funeral expenses, crime scene cleanup, and emergency relocation. And so the change from 5 to 10,000 was one of the things that they were interested in, because some of those costs are urgent. They're happening right now. And so.
Fiscal note. There's 11 staff in the fiscal note also at the bottom of page 8. 5 admin specialists, 5 admin officers, 1 lead fiscal accounts clerk.
Yep.
And then there's the grant money. Now, are those pins that already exist, or are we?
I don't have the answer to that question. Does Claire, do you have an idea of where?
I mean, they're not already being paid. I don't know if the actual pins exist or if they're gonna have to create pins. I don't think it says.
All right. Delegate Kaufman.
Yeah, well, earlier, and it's just because I can't see well, so earlier, just in, you mentioned that Eric was here. Is Eric here, Miles here,
Well,
anybody? Because it's an admin
But they
bill.
can't, we don't allow people to do that in the middle of a voting session. I'm sorry.
Okay, I
So
thought we,
that's why I've been saying, if people have questions, I'd prefer that we just hold it and then we can come back and take and I can get a little bit more information from the administration so that we can address some of those questions. Delegate Roberson, is that all right with you? Okay. Yeah, go ahead.
It's more of if this passes, because to your point, you're getting pressure from across the hall. I'm just wondering processes, maybe this is an off the record question.
When I say across the hall, I mean the appropriations.
No,
committee,
I know
in the
what you're
middle of the budget, we're making sure that there's actually enough money to, keep the lights on.
Right, and I was just my question is, as far as if we approve this, and what does the next step say for them to find the money?
Well, they'd have to find money in the budget because it's a may, not a shall. So they'd have to find money in the budget for it to begin with. So it would become an issue where they'd have to figure out
And they'd have to offset
how
it.
much, right? And they'd have to figure out what offsets are there.
So we're basically giving them another task.
So a little bit.
Okay.
There's that. So having said that, it's an administration bill, so I suspect that the administration would have an interest in doing something. So just to be fair, I'll hold on to it for a day and we will get answers to those questions and go from there. Yes, Delegate Williams.
I think I had stepped out on House Bill 565.
Does anyone mind if Delegate Williams votes yes on House Bill 565 for Delegate Simmons? All right, Grammer and Williams vote yes on 565. Okay, I think I'm sorry. There are amendments to 583. I think I need to hold on to this one as well. Because there were a couple questions and I want to make sure that we're getting these amendments right. So everybody hold on to 583. And we're going to hold on to 810 as well, because we are going to hold on to it just for a day. People have potential amendments to 810. They want to give them to the office as soon as you can. 832, Delegate Vaughn Stewart's legislation. There aren't any amendments to this one, and there's a motion for a favorable. Is there further discussion? All right, seeing none, the Vice Chair.
Yes.
Yes, Crutchfield, Carden, Embry. Yes, Pasteur. Yes, Tolles. Yes, Schmidt. 832, sorry. 832. I'm looking at Schmidt. I didn't get and I know that he's looking it up. No. Simmons? Yes. Boucher? No. Phillips? Yes. Roberson? Yes. Tomlinson? No. Arakan? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. All right, I'm gonna go ahead. House Bill 978, I believe, has amendments. This is Holly. Holly, would you mind telling the committee what the amendments do? I think it just, does it make it?
It basically
Report?
strikes the whole bill and just requires the Maryland judiciary to report on what they are currently doing with the text messaging in the court system.
This is motion for favorable second. This went to subcommittee if I'm not, am I right about that? Or no, it
No,
didn't?
it didn't.
Oh, okay. But this was, I think the sponsor came forward with these amendments. I think the judiciary is, he met with the judiciary and they're as okay as they're ever going to be about anything. So that's fine. Further discussion on the bill as amended? Oh, well, on the amendment, we did that. On the amendment? Yes, okay, Delegate Tomlinson?
Can you say that one more time? It's still, I mean, the whole bill is different now.
Holly?
So the bill as drafted was creating a text messaging system within the court system. But the Maryland judiciary said that they already are currently doing some of this. And with the spot, and it had a fiscal note. And so the sponsor and the judiciary met and decided that right now they're just going to report on what they're currently doing, and next session possibly expand that, but at least get everything under wraps and what's happening now, what needs to move forward.
The bill is amended. There's a motion for favorable. Is there a second? Motion is second. Any further discussion on the bill as amended? Seeing none. The vice chair?
Yes.
Yes, I don't know if I like what's going on over here. There's conspiratorial things going on over here. All right. Crutchfield she had to step out. Carden? Embry? Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. And an add. Roberson? Yes. Tomlinson? Yes. Arakan? Yes. Taylor? Yes. And an add. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? And an add. Kaufman? Yes. Williams?
Yes, and an ad.
And an add. Made those marks on the side here. All right, and that's House Bill 970 and Crutchfield 978, young text messages in the courts. Yes, Crutchfield is a yes. House Bill 1060, we have been here before, everybody. Now I can't find the folder. Did I move the folder? No, I did not move the folder, but that's okay. It's because it's 1060 and it's the sheriff's bill from Carroll County.
And everybody's.
We now have a letter from the Carroll County delegation indicating that they approved the amendment, which is before us. There's a motion for a favorable and a second on the amendment. Is there discussion on the amendment? Delegate Boucher.
Thank you, Chairman, and thank you for taking the time to revisit this. The bill went back to the delegation. Our delegation voted on it. I was only dissenting vote. I just want to emphasize the fact that this is a 51% increase in wage for a sheriff. And having been a former county commissioner who was in charge of giving raises to all the county employees, I'm aware that last year, our county employees received only a 4% raise. And I continuously hear from my constituents the struggles that they are having paying their bills, paying their escalating property tax rate, paying for their gas, paying for their groceries. And I just think this is an extremely inappropriate amount of wage to be giving a public official in the midst of an inflationary crisis, which is affecting all of our constituents. We just seen a Baltimore County sheriff bill for $157,000, and Baltimore County is much larger than Carroll County. We also seen a Garrett County sheriff raise, which was 80% of the state's attorney's raise. I think this is an exceedingly high rate to be paying our sheriff at this point in time. This raise would not go into effect until the next term, which is almost 3 years out. And I think it'd be prudent for us as fiscal conservatives in the county of Carroll County to hold off and wait for the sake of our citizens to make the decision later on this raise. Therefore, I think it'd be wise to hold off, and I ask that my colleagues on this committee vote down this amendment. Thank you.
Discussion on the amendment. Oh, we found the file. Seeing no further discussion on the amendment. I'm sorry? Okay. The amendment changes. As the bill was introduced, the salary for the sheriff was going to be equal to a lieutenant colonel in the Department of State Police at the highest available step for a lieutenant colonel at the state police. It changes that language. It says at the beginning of 2023, the salary for a sheriff shall be $191,078.10. Then beginning in 2027, the salary for sheriff, it would be $212,000 and $309. As I mentioned previously, there was a vote in that we had originally gotten a vote from the Carroll County delegation that didn't indicate whether or not that they had adopted the amendment that I just talked, that we're in the middle of talking about. The delegation met last 2 nights ago, and as was mentioned by Delegate Boucher, they voted 3-1 regarding the legislation as amended. And so, as it is a local bill, this committee traditionally shows deference in these cases. And so for those reasons, we're now on the amendment. Is there further discussion on the amendment? All right, we did that. We did the second. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. All opposed, please raise your hands. 1, 2, 3, 4, 5, 6, 7. The amendment is adopted. We're on the bill as amended. Is there a motion on the bill as amended? Motion for a favorable and a second. Any further discussion? Delegate Taylor.
Thank you, Mr. Chair. This may be a freshman question, but we had 3 of these, I think, on the floor today that didn't come through our committee. What's the distinction between this salary for a sheriff and the others that went through another committee?
I'm not quite sure why. We have seen these bills in this committee in the past. They have come through here in the past. I'm not sure. I'm genuinely not sure. I think we did something similar with Prince George's County a few years ago. It is something that we have done in the past. And so here we are. Here's the bill before us. That's all I can say. Any further discussion? Delegate Williams.
Thank you, Mr. Chair, and thank you, Delegate Boucher, for raising your concerns. I am very torn because I definitely understand where you're coming from in terms of the amount of the increase. But I also, we always give local courtesy to the local jurisdiction. And so I'm torn about this because I generally was like, if this is what you guys want to do, you like it, I love it. But thank you for raising that as a concern, especially for your constituents, so they know where you stand on this particular issue.
Delegate Tomlinson.
Thank you, Mr. Chair. Yeah, and the reason that the reason we did the amendment was because we did have concerns about how quickly it was moving, the salary jump, and that's why we did the amendment. But yes, all 5 of our county commissioners, they and it is the county that will be paying for it, and they all signed off on it and asked for a favorable report. So I appreciate it.
Further discussion. Delegate Moon.
Well, I would just like to say for the record, I'm going to support this bill and I'm going to support local courtesy. But I am with my friend over here. Yeah, I don't like every time we do these multi-6-figure salary increase bills while we're here. And I'll just say that on the record. So when I vote for these things, I'm doing so out of respect of local courtesy.
Thank you, Mr. Chair. And I'd just like to put one other thing in perspective. A lot of times with these elected official bills, we look at a 51 or a 61% increase, but we're thinking about it in 1-year terms. We're talking about people that a lot of times salaries have not been adjusted for 8 or 12 years. I don't know what this one is, but if you factor that in that mechanism, you're looking at about a 4 or 5% raise each year over that 8, 9, 10, 12-year period. And also put it in perspective, an agency that I used to work for before I retired, since 2016 in law enforcement in general, their starting salary in that agency since 2017 has increased 61%. So this is not unusual. We look at the dollar amount, it is a high dollar amount, but it's pretty standard in that jurisdiction in that area. So I just wanted to put that out there for the committee as well. Thank you, Mr. Chair.
Yeah, I do understand what Delegate Boucher is saying. We just put in a bill as well for our sheriff, who is the absolute lowest paid sheriff in the state of Maryland. And even with the increase, it is less than this. He still will be near the bottom because we tried to do it incrementally. So I understand it, but I also know that I'll be coming to somebody to vote and have that courtesy. So I'm just gonna stop with that so and an ellipsis.
All right, we're on the bill as amended now. All right, the vice chair.
I'm a yes.
Yes.
And
Crutchfield. Yes. Cardin. Yes. Embry. Pasteur. Pasture, yes. Tolls.
As a local council member, but previous, not now, never gonna do that, but previously, for the record, they keep calling me. I'm gonna give him this one. He doesn't ask for much, so I'm gonna say I'm a no.
Tolls is no.
Yeah,
Schmidt.
after-
Yes. Simmons. No. Boucher. No. Phillips.
Yes.
Yes. Roberson. Yes. Tomlinson. Yes. Go ahead.
It just hit me that a lot of the counties that the majority of you probably represent, whether it's Montgomery County, Prince George's, the city, you guys all have a chief of police who in a city or a county police department. Carroll County does not have a county police department. So whereas for a lot of you, I think you probably maybe see the sheriff maybe doing more just like courthouse related activity. Our sheriff's office is our police department. It's not, we don't have a chief for the county or anything like that. So just throwing that out there.
All right. Erica. Yes. Taylor. Yes. Simpson. Yes. Grammer. No. Moon. Yes. Valentine. Yes, go ahead.
In addition to the patrol and the field service type of responsibilities, the other thing a lot of counties don't have that our sheriff, or I'm sorry, this is not my county, but sheriff's offices in the rural counties, they're also in charge of the detention center, and many of the large metropolitan counties also have a Bureau of Corrections in their local county. So our sheriff is actually over 3 different bureaus in a lot of the rural counties to have corrections as well as patrol division, as well as judicial. So for those reasons, I'm a yes on this.
Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. Motion is adopted. House Bill 1267. House Bill 1267 doesn't have any amendments. It's a bill from Delegate Robin Lewis in a district that is close to everyone's heart, or at least my heart. All right. I don't know that that's true, but okay. Delegate 1287 allows for researchers affiliated with institutions of higher ed to be able to conduct research research, academic or policy research related to extreme risk protective orders or red flag or orders. Motion for a favorable and a second. Any 1267 is where we are. Any discussion? No. The vice chair.
Yes.
Yes. Crutchfield.
Yes.
Yes. Carden. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. No. Moon. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams.
Yes.
All right. Chair votes aye because it's Robin. All right. The motion is adopted and because the bill's good. All right. But also Robin. House Bill 1310. This is a Baltimore City delegation bill. It went to the Family and Juvenile Committee, who made amendments. There are amendments. Do you or does Lauren, can you talk about what the amendments? Lauren's going to do this. So there are significant amendments. The amendments were approved by Baltimore City delegation, please. Lauren on the amendments.
The amendments are pretty extensive. So just broadly what they do, they authorize access to and confidential use of juvenile police records by the Baltimore City Coordinated Youth Violence Review and Response Team. They alter the duties of the review and response team. They require each organization represented on the team to enter into a specified memorandum of understanding. And also they alter provisions relating to meetings, confidentiality of information, and obtaining the consent of parents before the review of individual cases.
Motion on the amendments. Was the amendment a second? All right, further discussion on the amendments? Seeing none, all in favor of the amendments, raise your hands. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Anybody opposed? Seeing none, we're on the bill as amended. There's a motion for the bill. Is there a second? All right, so we're on the bill as amended. Any discussion? Seeing none, the vice chair, Crutchfield, Carden, Embry, Pasteur, Tolles, and all of those were yeses. Schmidt, yes. Simmons, yes. Boucher. Boucher is no. Phillips, yes. Roberson, yes. Tomlinson, yes. Erican, yes. Taylor, yes. Simpson, yes. Grammer, yes. Moon, Yes, Valentine? Yes, Conaway? Yes, Kaufman? Yes, Williams. Right? Okay. He meant to say yes, so it's a yes. The chair votes yes. Balmer City Bill, when I get to vote on things. All right. House Bill 1330. Wait, whose bill is this? I don't know. There's a motion for a favorable on this questionable bill from Delegate Valentine. All right. The vice chair is already threatening to use her hold. This is a study on the location of people prior to and following incarceration. Do you want to talk any more about what you're looking for here?
Just, we're looking for data for some of the points you've just mentioned. It's come up in a couple of different scenarios. We've, in fact, on the House floor during this session where we talked about where individuals for voter registration, where they're living at or where they lived prior to incarceration, or it's just trying to compile that data across the state where everybody's at.
All right. Discussions about the bill? Did I do the motion? Can I have a motion on the bill just in case? Motion in a second. All right, fine. Any further discussion? Seeing none, the vice chair? Yes. Crutchfield?
Yes.
Yes. Cardin? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yeah, you can't add because it's not amended. Sorry. Boucher? Yes. Phillips? Yeah. No, not right now, but Roberson? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Moon? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams. All right. You want to ask your question now?
I just want to make sure that the information that we're collecting is aggregate information, right, Delegate Valentine? The information will be reported out in aggregate. We're not reporting individuals.
Not individual.
If I recall, it was aggregate.
Yes.
Right.
Okay.
Getting ready to write.
I'm fine.
Sure. Fine. All right, we're now on House Bill 693. 693, we are second. There are many amendments, but we're going to go first with my amendment. Again, we're second. This moved out of, okay.
This is probably easier to work from because this is the reprint they have. So this is surcharge, this is the misdemeanor strike, and then this is the tenant declines.
Okay. So amendment, the first one is going to be an amendment from the chair that addresses, what is it? The surcharges, and I think that's 433922, I think.
Yeah, so they're all gonna be under this with this timestamp because it's a amendment to an amendment from each.
So here's the deal. So on the top, what you want to be looking at is the interlineated copy, where at the top it says it's amended by 433922. The reprint is on March the 13th, 2024 at 8:58. It was emailed to you 20 minutes ago. What this is, it is the amendment. It is the amended version of the bill as it has left the subcommittee for environment and transportation. So we are second, not first, as I mentioned 30 times already. And so we are going to make some amendments. There's some amendments that are going to be offered here, and then they're going back to E&T. The first one is going to be a little bit difficult to find, but if you can go to, if you see in your upper right-hand corner there, it says bill page 15 of 18, and then you go 3 more pages. Now, what happens is the bill pages on these interlineated versions reflect the bill page numbers that the bill had when they were first introduced. So when they make changes to the bill, they all reflect, that's why one page suddenly turns into 3 or 4. The first amendment that I'm bringing before the committee has to do with the filing fee for summary ejectment, tenant holding over, and breach of lease cases. What I'm asking is to amend the bill as it was introduced, came in at $93 for those cases. For a summary ejectment case, I should have said summary ejectment, tenant holding over, and breach of lease. I would ask to lower that to $83 for those cases. And then it makes a couple of other changes. It raises the amount that just any district court case, not just rental cases. We haven't raised it since 2010. So it would raise those from $18 to $28. And I believe there was a circuit court and it's on the page right before, there it is. So this would be for all cases filed in circuit court, not just rental cases. It would go from $55 to $85. We haven't raised them for now 14 years. That money would go into the funds that are established in the bill, either for 45% for the statewide rental assistance program, 45% for the Maryland Legal Services Corporation, and 10% for rental assistance for Community Schools Families Fund. So the reason that I'm offering the amendment, it makes it similar to what we did in 2021. And for me, this is important to lower maybe not so much to lower the eviction fee, but it also ensures that we are refreshing the amount that is in particular going to MLSC, to the Legal Services Corporation, because they have been facing deficits for some time. And I'm hopeful that that $28, particularly in district court, will help to put them back in a place where they can provide those services. So that doesn't necessarily directly address issues related to housing, but it addresses sort of access to justice writ large there. So that is the first amendment we would consider. There's a motion for an amendment in a second. We'll do discussion on the fee changes, the fee increases. I understand other people want to do other things with fees, but this is just on the amount of the fees and the amount of district court fees. Anybody? All right, all in favor of my amendment number 1, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, all opposed. 1, 2. The amendments adopted, amendment number 1 there are going to be 3 that are coming out with the support of the chair are coming out, but amendment number 1 is adopted. Now, the second amendment that I am putting forward, and this comes from a conversations that I will not quite out them, but I will sort of out them with delegates Robertson and Phillips with regard to, oh boy, so let's see, that's page 12 of 18. 1, 2, 3, 4, 5. It is the 6th page of page 12. It is highlighted on your computer. It's right above, it's section J. And it says page 12 in the upper right corner, and then go 5 more pages to find in this heavily amended bill. 17 of 27 would be the easier way to put it.
Yes.
You know.
17.
Yeah. This is the point in the debate where Delegate Embry points out how hard poly people make things with math. So, and she's right, and I accept response. All right, that's fine. In the bill, it said
16. You don't have a PDF, you have a hard copy.
it was on, it is a.
It's not gonna be labeled, but it should be
Hunter's coming to help.
Hunter's gonna help you.
Hunter will help you.
So what the It's on page 12.
It's the fifth page of page 12.
The fifth page of page 12. But Hunter's gonna help you, and I'm going to read it. Okay, I got you. All right. Look at all these nice people here to watch us. All right. I got that. The bill as it came in said, an owner of a residential rental property who violates this section is guilty of a misdemeanor and on conviction is subject to a fine of not more than $1,000 per violation. The amendment would strike the words guilty of a misdemeanor and on conviction is. So it would read, an owner of a residential rental property who violates this section is subject to a fine of not more than $1,000 per violation. Effectively, it makes it a civil violation as opposed to a criminal one. Uh-huh. This is that one. This is that. There's motion in a second. That I think addresses the issue that you were raising, Delegate Tolles.
Can you, and I'm sorry, I was in another committee yesterday, so I missed a bit of the discussion. So the landlord would have violations, right? Can someone give me an example based off the discussion, what those violations would be in this instance where they will cause them to get a misdemeanor?
Well, again, the amendment would remove that language, so it would become a civil violation as opposed to being a misdemeanor and being a criminal violation. So it would be an owner of a residential property who violates the section. So there's a lot in 8.119.
Right, I just wanted.
Yeah, it would be not offering the right of first refusal, for example, would be subject to $1,000 civil fine under the amendment.
Okay, so it's not as if they did something egregious to the tenant. It would just be for the right of first refusal.
It would be the right of first refusal is what is in 8.119.
Okay. So I just want to clarify if it's,
Delegate Phillips.
Sorry, Mr. Chair. To that point, if a landlord does something egregious, there are other mechanisms to charge him with a crime.
I just wanted, thank you, Mr. Chair. I just wanted to, I think that, we do, I'm not a landlord, and so we have on both sides. I want to be able to make sure that our landlords, if something egregious does happen, or even if it was just notification, they refuse to do it because they're trying to, undercut the tenant, that it's sending a strong message that you should not be doing this, even if it's, in that instance, they would be charged maybe under a criminal violation because they may not have done anything criminal, but they certainly have done something that wouldn't be, in the fair to the tenant, I would say. So, and that's why I wanted that clarification. We do need to send a message. So thank you.
Everybody okay? Sounds great. All right, on this amendment, any further discussion? Are you okay? Oh, all right. All in favor, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Anybody opposed? Seeing none, that amendment is adopted. So now the third amendment, I believe this is David's. Okay, come quickly back if you can. All right.
This is just the 30 days.
This is the 30 days. Delegate Moon, you want to describe what your amendment does so I don't have to do all the work? Delegate Moon?
I just tried to suggest that we create a mechanism where the tenant, after finds out the property is being put up for sale, can waive their rights to the first refusal if they're just not interested, or if they don't have the money, and they're definitely not going to have the money, and then we don't have to run the rest of the process. There's no point in it proceeding if the tenants have zero interest in purchasing the property, so we can end the matter there. So that's what that does.
Move the amendment.
All right. Any further discussion on the amendment? Delegate Tolles.
Thank you. So I have a question for the amendment proposer. What if it's more than one tenant? So would you need signatures from all of those individuals? For example, what if it's like siblings and one of them don't have the money or not interested? Are you saying that everyone in the house has
No,
to do
yeah,
it
right. You're waiving it as to yourself.
as yourself?
Yeah.
Okay. And so
If you're in a multi-tenant scenario, then you're not waiving it for the other tenants.
Mhm.
You'd right. The landlord, if they wanted to sell it to someone other than that, would have to get all of them to waive
Right,
it.
all of them.
Yeah.
Okay. I just want to, make sure that's clarified. Okay, thank you.
Delegate Kaufman.
Tell us to, that an amendment is friendly and sometimes you tell us to resist an amendment. Do you have an opinion on the amendment? Okay, thank you.
Delegate Crutchfield.
Yeah, I thought it was already in the bill. No?
Holly.
No, it wasn't in the bill, and the way it's drafted is not necessarily a waiver. Delegate Moon, I just want to clarify. It says if the tenant or group of tenants affirmatively decline the offer, the landlord doesn't have to wait that 30 days. They can put the property up for sale. So there's not that waiting period. Exactly. And if it's a group of tenants, they all have to decline. The landlord just can't hear it from one. So if it's a multi-housing situation. Okay.
Fine. Or is it verbal?
It just says affirmatively decline.
I think
We can put it in
I
writing.
think it needs to be strengthened to be verbal.
I'm sorry. Blast for the past for law school. Statute of frauds, everybody. Statute of frauds. How about that?
Yes.
I
Yeah,
know, right?
but can't it still be it can't be verbal?
No, because it has to do with
Okay, so they
property.
have
It's
to-
real
it's property
property.
law, yes. Boom.
I'm both deeply concerned that this committee got so excited about the fact that we actually remembered something from law school.
You never forget
And-
statute of frauds. That's
Don't say it. We're not gonna do the rule against perpetuities.
We talked about that today. That was like.
Okay, we're not gonna talk about that anymore, though. We're on the amendments, then now that the non-lawyers in the room are irritated and rightly irritated. Any further discussion? Delegate Taylor.
That's why I asked yesterday, when does the real estate agent get involved? Because if they're involved at the very beginning, then there should be some form that would, that would capture the fact that they have waived, right? So is that what's gonna happen? I'm just making sure that we've
So
settled there.
our excitement at shouting statute of frauds is there's a rule broadly that says that you have to put it in writing if it has to do with real property. And so that's what we're dealing with here. And so, yes, if it was affirmatively stated, then you don't have to say that it's written in the law that because of the statute of frauds, you have to have that expressly written. All right, Delegate Phillips.
This comment, I think, Delegate Taylor, from a practical perspective, what is going to happen is real estate professionals will follow this, and then they will come up with a set of forms. The realtors, they're going to come up with a set of things to protect themselves. The title companies are going to come up with set of forms to protect themselves. If this passes, that's what's going to happen.
All right, anybody else? Okay, all in favor of this amendment, please wait.
I'm sorry.
Oh, Delegate Embry, I'm sorry.
No, and I'm sorry, I just can't find it. I like the spirit of this bill, but I just to follow up with Delegate Crutchfield, it seems like under the existing law, if they decline before the 30 days is out, the landlord doesn't have to wait, but could you just point to where?
The issue was it's not explicitly listed, and there was some concerns that it should be there, that they don't have to wait, and there's no confusion. And
Even
this
though
would,
it doesn't say that they, okay.
yeah, so this was clearing it up. It's kind of inferred that they don't have to, but they wanted it to be clear and to have something in the bill to make that clear that the landlord can just put the property up for sale and there wouldn't be an issue.
Thank you.
On Delegate Moon's amendment, Chair considers friendly. There's a motion and a second. All right, all in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 20. Anybody opposed? Seeing none. Okay, so now there are other amendments that I don't know whether they're being offered anymore or not. So we're going to go ahead and look around the room. Does anybody want to offer amendment? Delegate Cardin and then Delegate Crutchfield. Delegate Cardin.
Thank you, Mr. Chair. I just want to make sure I have the amendment number.
I see 773724.
Yes, 773724.
What does your amendment do?
The amendment does two things. The first thing that it does is that it instead of having the $83 as amended, the $83 non-recoverable fee, it allows, if in Maryland District Court does not grant the landlord relief in a summary ejectment action, the court may assess a surcharge against the landlord in the amount of $100. So it's a $100 fee instead of the $83 fee. It is non-recoverable because it's assessed on the landlord, but it only happens if the judge does not grant the landlord the relief that he seeks. So I tried to do something that was a compromise that also gave a little bit of predictability. And I don't think that the multi-housing folks are thrilled with this. I don't know. I'm assuming the administration's not thrilled with this, but it was sort of like in the middle. The language is based off of House Bill 174, which if you pull up House Bill 174, it is about taxes. It's about property taxes. And what it says is, if you look at it, on page 3 of the bill, this is the chair of Ways and Means put this in for the administration, that that if the Maryland Tax Court does not grant the taxpayer relief on the appeal, the taxpayer shall pay a fee of $100 to the court. So basically what you're doing is you're saying that if they're just bringing them in to do the collections and they are and the judge isn't giving them what they want, then they can get that a fee assessed. The judge can assess the fee to them. So I think it, for all intents and purposes, it accomplishes the same thing, but at least gives good notice that you are that they're going to get this fee put on them if they don't think of other ways to collect the rent. That's the first thing that the amendment does. The second thing the amendment does is something that I had asked Brad. Thank you. I asked Brad yesterday when we were questioning him, which is if you're going to reduce the escrow amount by 50% in terms of your security deposit, why not allow the landlord to ask for an additional, not a lot, but additional money of $200 that can only be used in a rent or in a eviction type proceeding, and if it hasn't been used within the first year, it gets returned with interest back to the tenant, as a way of just kind of giving everybody notice that there's this money here that would be used if you are late on your rent. I thought that was a good compromise as well. Those are what the two things do. I tried to bring everybody together and do things in what I thought was a reasonable way.
Motion for a favorable, is there a second? So we're not going to take that amendment up. We'll go to the next amendment. Who'd like to offer an amendment?
Fought like a
Delegate Crutchfield.
So my amendment is 843-723.
843-723, renaming the
Yes, that is correct.
office from the tenants' rights to tenant and landlord affairs.
That is correct.
All
And
right,
it's amendment number 1 and 2, which just everywhere changes it to tenants and landlord affairs versus tenants' rights.
motion for a favorable in a second. We're on the amendment. Any discussion on the amendment? All right. This is something that we have discussed, I think, pretty extensively around the committee. You know, at this point, I think that this bill has a long way to go. And so, I think that this is a reasonable amendment. All in favor of the amendment, please raise their hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. Anybody opposed? 1, 2. All right, the amendment's adopted. So, all right, we are on the bill. Are there any further amendments to this bill? All right, so again, we're secondary, so we're sending this up to E&T. They could turn around and say, we don't like that and send it back. So we're gonna go, but that's where we are. I don't see any delegate grammar.
I think I might have an amendment now that we've adopted those. Would it be okay to hold this today?
So we're second, and the problem that I've got is that they're ready to vote on it upstairs. So that's why we gave people fair warning to get amendments in. There were several that were submitted, so I'm gonna move forward with the legislation. Is there anything? I don't see anybody else offering an amendment. There's a motion for a favorable. We are again second and a second on that. Further discussion on this bill? Seeing none. The vice chair.
Aye.
Aye. Crutchfield.
Yes.
Yes. Cardin. Okay. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Go ahead.
And I'm willing to work with the committee. I'm willing to work with the secretary on this. But I'm a no today. Thank you.
Thank you. So that was a no. Simmons. Yes. Boucher. No. Phillips. Yes. Roberson. Yes. Tomlinson. No. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. No. Moon. Yes. Valentine. No. Conaway. Yes. Kaufman.
Yes.
Yes. Williams.
Yes.
1 moment, please. 6, 7, 8, 9, 10, 11, 12. Chair votes aye. C-15. Ladies and gentlemen, that the motion is adopted for favorable to send to the Environment and Transportation Committee. Ladies and gentlemen, that's the end of today. We're going to have a similarly long voting session tomorrow. Please stay tuned for subcommittee announcements. For now, we are adjourned.